All right, we're ready to begin our Orca calendar for today, which is Thursday, January the 5th, 2023. This is our Orca status calendar. I will call the cases and go through the calendar first. And then I may come back and revisit some cases depending on what the announcements are. So let me see who we have available and who we have on Zoom. And then we will see what our disposition should be. First case on the calendar is Ali Balori, B-O-L-O-U-R-I, or Balori.
I'm here. I'm on Zoom, Your Honor.
Okay. Say something again.
I am here, Your Honor. I'm connected to the Zoom call.
All right. In order for you to participate and in order for me to speak with you, I have to see your face. You have to turn your camera on. All right. Thank you.
Is that better?
Yes. And your announcement is? Are you represented by counsel?
Oh, no, I'm representing myself, Your Honor.
All right. And what is your announcement for today?
I'd like to plead guilty to the charge and pay the fine.
All right. Which ASG do we have for this first case?
Your Honor, that would be me.
All right. That's ASG Tortorella. Are you prepared to take a plea today? Yes. All right, we're going to have someone speak with you. Mr. Pronounce your last name for me.
Buluri.
Glory, okay. Have someone to speak with you, and we will come back to you for that plea, okay?
All right, thank you.
All right, thank you. Please hold. Next case is Terrell Davis. Terrell Davis.
Good morning, Your Honor. Attorney
Good
Peter
morning.
Simmons for Terrell Davis. I'm present. I don't see my client on the call, and I have not had contact with him recently.
And Your Honor, if counsel's client is not appearing in court, the state will request a bench warrant.
All right, if he doesn't show up, we will request a bench warrant. Mr., is it Simmons?
Yes, Your Honor.
All right. Has it been a long time? How long has it been since you've had contact with them?
I haven't spoken with him probably in the last couple of years.
Couple of years, okay.
Yeah. I've checked around, looked around for him in a bunch of different places, and I have not located him. The numbers don't work, and the address the court sent a notice to, I believe, was returned to the court.
All right. Hold on one second. Do we have a return notice, Madam Clerk?
I will verify, Your Honor.
You will check that real quick.
I do have a return sending November 17th.
Okay. Well, he has a duty to keep his address current. And I will hear that in a second, but it looks like it will be in bench warrant status.
Yes, Your Honor.
And if you have any other business, you can either hang around or you can leave us. Which would you like?
No other matters before the court today, Your Honor. May I be excused?
Yes, you may. Thank you.
Thank you. Have a great day.
You too. Next case is Bruno Delva. Bruno Delva.
Good morning, Your Honor. How you doing?
Good morning. Yes, your announcement, Mr. Delva.
And Your Honor, this.
I'm sorry, my announcement?
Hold on a second. Yes.
Defendant does have counsel, it's Attorney Frank Hicks.
Where, do you still have Attorney Frank Hicks representing you?
Yes.
All right. Is he on the Zoom?
Not sure. Just came in.
All right, I don't see Attorney Frank Hicks. We'll
I see-
hold for a second. Sometimes the attorneys may be doing double duty. Maybe running a little late from another court. Let's hold for a second to see where your attorney is, okay?
Okay, Your Honor, thank you.
Thank you. Jalen Hines.
Good morning.
Yes, Your
Judge
Honor, I'm here.
Christy Battle for Mr. Hines. We're on Zoom. Mr.
Okay.
Hines is also here.
All right,
Judge, we received an offer which is inclusive of some time, but we've not received any discovery, and I reached out to Ms. Falk about that. But to date, we have not.
all right.
And Your Honor, the state did file discovery on December 5th, 2022. But of course, and I believe council did file an entry of appearance on December 9th, 2022, after we filed discovery. So that may be the reason.
Discovery has been filed in that case. I don't know if you could hear the state. It was filed before your entry, but it was close in time. Give me those dates again. I think she cannot hear you, ASG Tortorella.
Yes, Your Honor. Discovery was filed by the state on December 5th, 2022. Council filed her entry of appearance on December 9th, 2022.
Oh, it's just a few days. The state filed their discovery on December the 5th, and you filed your entry on December the 9th.
Okay, so is there a reason why they can't send it to me? And are there should be some videos inclusive of that discovery.
Let me see. Hold on a second. But you have access to e-filing, correct?
I do have access to e-filing, but the access that I have does not allow me to get everything that they have.
Have you requested a video from them?
I requested all discovery from them, which is inclusive.
Okay. You did that on the 9th, the same day that you filed your entry?
Yes.
When can we get the discovery to council?
Your Honor, we could go ahead and refile initial discovery under her name. Maybe that's the issue for the e-filing situations. That way she can have access to discovery. And we'll also request video if there's any video.
All right, they're going to, well, I know how it works on the Superior Court side. You would have that access. You signed up for e-filing, so I'm trying to figure out why you wouldn't have it on the state court side.
And Your Honor, respectfully, yes, once we file the discovery to the clerk's office, whoever enters an entry of appearance on that case, they should be able to access it. We don't file it particularly to the attorney, we file
it to the case.
Yeah, of course, the video, we have the same video and we'll send that via link, via evidence.com for counsel to access it. But she should be able to access the documents that we have e-filed into the clerk's office.
That's what I was thinking. I was just making sure I wasn't incorrect before I said that. Counsel, once you filed your entry of appearance, you're on the docket as the counsel in that case, and you should be able to go back into e-filing and print that discovery that was filed a few days before your entry. They will order the video again for your access to evidence.com and send you the link as soon as they get that for the video. But as far as any pleadings or documents, you should be able to sign in to e-filing under that case number and print or access any of the documents that are available to you, which are most of them through the e-filing system. Have you looked at that?
I will, this is something new that's been going on, Judge, because I've never had this issue before with just receiving discovery once I file. It seems as though the prosecutors are now requiring us to go through e-file in order to get discovery. And so I will do my due diligence to try to figure it out, but I've just never gone through this before where I have to go and it's not like it's showing me, hey, this is the discovery and this is where you need to go. So
Well,
I'll go through Odyssey and see everything
Right.
that I've ever seen with Odyssey makes you pay for stuff. So
Well, you may have to do that, unfortunately. We can't control that, but it is there for your availability, and it may charge you a fee. But that is the way that the court systems work with the requirements of e-filing, is that it does not limit you from accessing it. It just may be a cost.
well,
And it's
Judge, this is a criminal case, and so for my client to have to pay for any discovery seems like that's unconstitutional. So I mean, I would have an issue with having to have my client pay costs for discovery that he's entitled to by law.
I understand, but if the clerk in the e-filing system charges $1 per page to print, other than you coming down to the solicitor's office to obtain a copy that way, then that's what that would be.
And Judge, respectfully, I just wanted to, again, as the court knows, there's a law requires that. That is the statute. I believe it became effective in July of 2022.
Mhm.
Sometime around then, the state is required to e-file. That is the law council. And so we have to e-file to the clerk's office, and then you either have to access the case that way or come down to the clerk's office. But that's the way the state is mandated by law to file a discovery.
Right, mandatory e-filing.
Well, Judge, we're required to e-file also, but that doesn't mean that we don't give copies to the state of anything that we have, of discoveries, of motions, or whatever. The state changes solicitors or prosecutors all the time. And some of the times they don't have it, they haven't accessed it, and we just provide that because we're required to. So I'm just confused as to why. I mean, that it's just a violation of his rights to have to pay for any discovery. I don't, Fulton County is the only county that's doing this. So I'm just confused as to why the clerk thinks that it's lawful for them to withhold discovery or require a
Well,
criminal.
they're not withholding it. You have access and availability, Mr. Jordan, to the discovery. Mr. Jordan? Hold on 1 second. I'm going to get a representative from the clerk's office to explain or to find out about the cost. Okay, he's coming on in a second. Actually, you're the first attorney who's brought that up to me. So I appreciate you letting me know that.
Your Honor, respectfully, I used to be a public defender, and only public defenders were able to get discovery by not paying the page. Because I believe even as a private counsel, you would have to pay something to get your discovery in the clerk's office.
Right, I think the PD's office is the only
That's right.
office that has access to not pay the cost. The private counsel, there is a cost now being levied by the clerk's office. As soon as Mr. Jordan gets on, let me see.
Just to chime in on the conversation.
Yes.
When I was in private practice, that was one of the counselors raising the issue that I had.
Okay,
Because the clerk's office, from my understanding at that time, they call it a convenience fee. And so you would have to come to the clerk's office and use their computer for free, but there was still a fee involved.
Mhm.
It's like, well, hold on. And especially when I was assigned as a conflict 3 attorney. So I'm a private attorney, but I took court appointed cases.
Mhm.
So my funds is very limited to almost nothing. So I'm like, I don't have it to pay for all of the extra discovery. So that was the issue that I can attest to with cost was the issue I ran into when I was in private practice.
Wow. Was it unique to Fulton, or do you know?
It was unique to Fulton because when I was a C3, I took cases in Farrell County, other counties, and to avoid the cost, what we did, the solicitor or the DA's office would require you just to bring a jump drive. You know, jump drives are cheap. Okay, cool. I'll bring a jump drive, go to their office, and then I can give it to them, or they'll say, well, no, here's the computer, just go plug it in and download what you want. And that's how it was done there or in Cobb when the DAs and solicitors still didn't go away. They either gave you the jump drive or they gave you a link
All right, I have a representative from the clerk's office is coming to the courtroom attorney battle. And again, thank you for making the court aware. Let's see what his explanation is, because I'm sure everyone on Zoom wants to hear this explanation as well as hopefully getting a solution so that you can obviously promptly get your discovery.
Thank you, Judge. I just want, you know, if my client has to pay for it, well, we do to get the discovery, but as far as the videos, I don't know about those either. And we would just need time to just be able to get the discovery period and read it.
Correct.
Your Honor, about the videos, the way we do it is we will provide a cover sheet stating that if we do have it, we'll e-file that, and then we'll directly send counsel the videos through evidence.com via email.
Now, is there a cost when she accesses it through evidence.com as well? That's free?
There shouldn't be a cost. No.
Okay. Yeah, accessing the video through evidence.com, I understand there's no cost. And I'm going to venture to say if you're able to come down, there may not be cost in getting it from the clerk's office. But this person I think is walking to my courtroom real quick. I'll see what his explanation is. I'm gonna hold a second attorney battle and go to the next case. And then as soon as he comes in the courtroom, I will address that with him so that he can explain what the policy is and see what we can do about that, okay?
Thank you, Your Honor.
All right, hold on a second, okay? All right, next case I have is Carnegie, Judy. Say that
Good
again?
morning, it's Carnegie Judy, Your Honor.
Judy, okay?
Your Honor, we were just retained on this case yesterday evening. We'll be filing into the case as soon as I'm back in the office today. It's Attorney Brandon Rosenblum, bar number
All right.
111908.
All right. And so we are resetting it for you, Mr. Rosenblum.
Yes, Your Honor, we'll go ahead and e-file everything today, and
Okay.
I'll reach out. Who will be the prosecutor on this case?
Your Honor, we don't know this time.
Say that again. ASG Tortorello.
The solicitor who's overseeing this currently is Deputy Shelley Falk.
Deputy Shelley Falk.
Is that F as in Frank?
Yes.
Okay, I'll reach out to her and we'll see what we can do to resolve.
All right, and it looks like we're going to reset you for, is that January 26th?
Yes, sure.
All right, January the 26th
Okay,
at 9 a.m.
we'll get everything filed, and if there's any conflicts, we'll send that to you as soon as possible.
All right, thank you.
Thank you. Have a
Okay,
great day.
and check your chat, Mr. Rosenblum. I think the clerk sent you a message.
Doing that right now.
Okay, thank you so much.
Once he files his entry, the discovery has been filed, we'll be able to access it.
All right, and once you do your entry or file your entry, should I say, that discovery will be accessible for you. If anyone wants to listen, once my clerk's representative comes down to see what the cost factor is. But you will have access to it on the e-filing system on Odyssey.
Understood.
All right, thank you, Mr. Rosenblum.
Thank you. Have a great day.
You too.
Your Honor?
Yeah.
Did you call on position 5?
That was position 5.
But it was,
I think he's position 6.
yeah, Judy.
Judy, Carnegie Judy.
Oh, we have different numbers, obviously. Do I have earlier heard that is Carnegie Judy, represented by Attorney Rosenblum? I have it as 5, you may have it as 6, but it is Judy. Sorry about that.
Wanda Jackson was taken off the phone and shot there for simple battery.
I don't have a Jackson. Right, that one was removed. The next one I have is Jerry Richard Lockhart. Mr. Lockhart?
He's here, yeah. Come on up.
Oh, he's live, okay.
Yes, ma'am, I'm here.
Hold on. No, that's Mike Lockhart on Zoom. You yourself, Mr. Lockhart, not you. This is Jerry Lockhart.
Oh, my fault. I'm sorry.
It's okay. All right, you're Jerry Richard Lockhart, correct?
Yes, ma'am.
All right, and what is your announcement, sir? Are you still represented first?
Yeah, but Mr. Coxon,
Yes, Mr. Coxon.
I'm waiting for him to get here. He said he had prior,
So he's on his way?
yes, ma'am.
Okay, we hold for your attorney, okay?
Yes, ma'am.
Thank you. Now I have Michael D. Lockhart.
Hey, Your Honor.
All right, good morning. What is your announcement?
My attorneys are running a little late from another court. He should be there shortly.
Okay, that's Sean McElhaney.
Yes, ma'am.
All right, we will hold for attorney's announcement. Oh, you have two cases, Mr. Lockhart, is that correct?
Yes, ma'am.
Okay. All right, next case is Travis Manuel. Travis Manuel.
Good morning, Your Honor. Ms. Brown Melchior here for Mr. Manuel. He should be on the call, but I don't see his name.
Yes, I'm here.
Okay.
Oh, iPhone 2. Do you have a camera?
Yes, I'm
All
trying
right, turn on your camera, please.
to click it.
Well, at least now we see your name. We're making progress. Let's see.
Oh, one second. I got it.
There you go. Okay, good. All right. What is your announcement, attorney?
Yes, Your Honor. So we did receive discovery. However, discovery has some outstanding documents. We didn't receive the accusation in the case, body cam, or the police report. So we are asking for a one-time continuance to get that information, then to be able to also speak with the state. We do not have an offer in the case, and I'm not sure who the solicitor is on the case either.
All right. Let's see what we can find out for you. Hold on one second. Muted myself. Again, Attorney Battle,
Yes, Your Honor.
I had one of the deputy clerks, Mr. Emden.
Oh,
Here.
Ms. Battle. Okay.
Yes, and hold on, yes. I am going back to the issue of the clerk. Ms. Battle states that, for instance, in her case, the state filed discovery on December 5th. She filed an entry on December 9th. And so there was no automatic discovery going there. We've not heard of that automatic happening. But she states that Fulton County, their uniqueness, is the only county that charges the fee or cost to print to access that discovery.
Okay.
I don't know if that's true or not. So is there a cost if the attorney enters after the state has filed their discovery for them to print it out, or is there a cost per page or something?
So there's a cost through Tyler to print copies from offsite.
Ah, okay.
So if you are on site at the public access terminals, you can view
And
or
print.
retrieve copies from that without a cost. But the cost is for the copies and for reviewing and printing them offsite.
Okay. So Ms. Battle, what Mr. Emden stated was that if you are in the courthouse using the public access portals or computers, there is no cost. But if you're off-site and you're printing, there is a cost through Tyler Technologies. It's not necessarily the clerk charging that cost. It is Tyler who created Odyssey.
Yeah, there are fees for.
And that's more of a fee as opposed to a cost.
Okay.
Oh,
Yes, so there are fees that the clerk does charge for printing, but for viewing the case records, there's no charge for viewing the case records. And I believe in previous situations that was Solicitor Gamage's view as well. The law says make available for copy or inspection. And so you can inspect the record by coming to the public access terminal without a fee.
Okay, so Your Honor, my question though is, who did the state serve? I mean, because I didn't file an entry until the 9th, and so they are required to serve it upon someone. So who did they actually serve? Because they didn't serve me. And I just looked at Odyssey. Even the accusation with the bind over has my name on it, and it has my client's name. So they had knowledge that I was attorney of record. So I'm just trying to figure out who they served, because it wasn't me. They have to have a certificate of service attached.
In response, basically we're serving the discovery to the case, to whoever's involved in the case, the parties. So once it's served with the clerk's office, which we did on, I believe, December the 5th.
right.
There is no counsel of record, but the discovery is there for the counsel of record. So what the law requires is that the state must make a discovery available. And I believe the statutory language specifically is to inspect, copy, and photograph. We do that by filing it with the clerk's office. Once counsel puts themselves in the case by filing an entry of appearance, then they can access the discovery of battle. And as the clerk just explained, you can come down to the clerk's office and for no charge and print out and look at the documents view, which is what the statute requires, and we make it available, we being the state, the Solicitor General's office, for you to, as I said, the statute, I believe, says specifically copy, inspect, copy, and photograph, I believe is the statutory language, and so that you can do that. If you want to print it out, then of course there is a fee from the clerk's office, I imagine, to print it out. Some prosecuting attorneys' offices may allow you to kind of print it out for no charge. Most prosecuting attorneys' offices, I'm personally aware of, there is a fee involved if you want to provide a flash drive, if you want to provide a CD for the state to provide discovery to you, or if you want to come in and print it off from the state's computer system. But the law now, counsel, respectfully, only requires that we serve the discovery on the clerk's office to the case. And then once you put yourself in the case, then you have access. And so the law deems that you are now served, the state has served you with the discovery. Of course, the video, any physical evidence, audio, video evidence, that is different. And we would have to provide that to you via a link so that you can access it through evidence.com, which we will do once we physically obtain the link ourselves and then forward that information to you. But, and I know the judge, just respectfully, there's been a lot of questions surrounding this, because I know in the old days we would email something to counsel, we would come by our office and we pick it up. But now this is what the law requires that we have to do. We have to file it with the case by e-filing. So if you have any other questions, I would just direct you to our, the attorney who is over our legal support system and all of our discovery. Her name is Anna Helena Allen. It's her last name. You can contact her. Anna hyphen Helena and last name Allen. And is very up to speed, if I might say, on what the law requires the state to do. And so, counsel, if you have any questions, please reach out to Ms. Allen. You can reach out to me. If I don't know the answer, I'll refer it to you. And thank you to Mr. Ender for providing that information to us.
Right.
Judge, one more thing, if I can add about the accusations. Many of these cases, counsel, will file as citations. The case was initially filed as a citation. We have gone back in preparation for court and we have filed accusations. Oftentimes you cannot see, I'm looking at a case today, I cannot see the accusation because we just filed it last night.
Right.
And so it takes a while for the clerk's office to actually receive our e-filing, process and assign a CER number. But once we get the accusation, we will forward that to you if you do not have one. But you should have access to the citations and or warrants that have been e-filed.
And I think you said you saw the accusation, correct, Ms. Battle?
I'm sorry.
Stated that you did see the accusation, is that correct?
What happens, because I went back on Odyssey while you were continuing on. What happens is you can see the first page. So really it's about the public having access to the records, not specifically the defendant or his or her counsel. It's about everyone creating an account and being able to have access because they're public records.
Right.
I'm looking at 1716.4 and I'm trying to find the part, but I will have to address this later. I don't want to take up the court's time.
Right.
They do have more discovery that they need to provide to me. But the very end of 1716.4, which talks about discovery creating threat of physical or economic harm. So all I'm saying is that this is new. Usually when an attorney files an entry, once they file an entry, then after that, they are served with discovery. I have never gone through this or known that. I see now that they're trying to just make us go through Odyssey or Tyler in order to get discovery. But this is just something very new to me. I'll have to do more research on the law. I don't agree with how the state is trying to make us go through Odyssey to get discovery when this has never happened before. But I don't want to take up any more of the court's time.
Right, and I appreciate it. It is important information, but again, the record and the formal record for the case would be the docket on e-filing, and that is the clerk's record and docket, and the official record for the case. And although you entered a few days after, you do have access to it. And I guess those keywords, inspect, copy, photograph, and have access, now that we're e-filing in state court, like we do and have been in Superior Court for many years, now state court has that e-filing requirement and that it is available for your viewing. And I understand that the cost may or may not be imposed by the clerk, but by Tyler Technologies, because you're printing off-site. And we obviously the clerk may not be able to control that. And I know that we will look into it, but I believe by the statute and talk to, I think it's in the chat, Miss Anna Helena Allen regarding the access. But I believe the days are changing a little bit with our online and e-filing, where it is not going to be mailed to you. It is going to be provided to you to have access through the official record and docket of the court, which would be Tyler Technologies Odyssey /e-filing. It's a little different now that we're getting into the e-filing world.
Judge, I just want to, before I leave, just bring up the whole issue of the certificate of service. They have to show that they have served me or my client with discovery.
Right.
With that comes a certificate of service. If we were headed for trial and I said, Judge, I haven't received this, and that. They are required by law as part of the civil procedure or the rules of procedure to provide a certificate of service saying that they served me specifically with certain discovery. And I can file motions based off of that. Filing it in an e-filing system or filing it on Tyler does not show a certificate of service that says that it has been specifically served to me. And so though that's the law, and the law hasn't changed as to the certificate of service. The law, what they are saying is you have access, but that doesn't say that I specifically have been served, nor have they shown through law that they have served me with that certificate of service. So that's the only issue, that there are still laws or procedures by which they are supposed to serve me, and serving me through Tyler or through the internet as they have done. The law has not addressed that as I know of, but I will reach out, or I'll do my due diligence to see how that is going to play.
Okay, very good point. All right.
Judge, respectfully, I was just going to ask if counsel, respected counsel, Ms. Battle, if she wants to file motions in this regard, the state will stand by its position that it is complying with the law that has been recently enacted last summer. That is what the law requires of us, and the state has, we feel we have fulfilled our obligation. But counsel, if you file any motions and any other issues regarding this matter to bring before the court, then we'll be prepared to address those at that time.
Okay. And I think this law, this change was last summer, so it's not, it's still what we would consider new. And you're right, we'll have some things to look at on both sides.
I was not talking about filing motions. I was just bringing up an issue of the certificate of service.
Okay.
Well, counsel, if you're challenging the statute, you're doing what the statute requires us to do. So
right.
If that's an issue that you want to address legally before the court with some motion, the state is complying with what the statute requires, and we're filing a certificate of service through the e-file system as the statute requires us to do.
Okay, I got it. All right, well, thank you, Attorney Battle. With your case, what are we resetting? I know that there was a conflicts letter for today, but you are here. And so what would be the disposition? You're waiting to get discovery, so I'm gonna go ahead and reset this to January the 26th. Is that the date, Madam Clerk? So we need to reset you at least to January 26th so that you can get the discovery, correct?
Thank you, Judge.
Okay, so I'll do that. You reset January 26th at 9 a.m. And hopefully by then, you obviously will have the discovery.
We had some cases.
And then you could be ready to go forward. Yes, ma'am.
Ms. Battle, we have any other questions regarding the case, or if you want to talk to the retrial case? Ms. Falk, who is the deputy over these calendars, is on leave this week, but you can talk to our main number, which is 404-612-4800, and I'll try to further discuss this and see if we can.
What was the last four?
4800. But Deputy Falk is assigned to the case, but she's on leave this week. So if you do call the 4800, you can ask for Deputy McCutcheon.
Deputy
McCutcheon, McCutcheon. Uh-oh, I missed a letter, didn't I? CUTCHEON, right? And she can try to help you with the matter before Deputy Falk returns next week.
Okay, thank you, Judge. And I'm sorry, I apologize for taking up your time.
Oh, that's okay. No, thank you.
Not excused.
Yes, you may be excused too. Okay,
thank you, Judge. May I be excused?
Yes, you may. Thank you.
Thank you. Have a good day.
Yes, exactly. Yeah, thank you for that.
Person can come to the clerk's office and you can view it. There's just a fee associated with printing it out.
With printing.
You can download it. You can download it as well. With the zip drive. Yes, at the clerk's office.
They can download for free on their jump drive.
It was.
I better not say that.
This was prior to the pandemic. That was the last time I did it. It was
Prior to the pandemic,
it is
right.
now. I can't speak on that.
The clerk here, the litigation manager, says you can download it to your jump drive.
Okay.
They won't charge
That's
you
the
for
same.
that. Right. All right. Thank you for everyone's indulgence on that. Carlos, I'm sorry, yes, I have an attorney, so,
Judge, and I think you called my client's case right before I entered. I wanted to come actually in person. I actually had a discovery issue, but I think a lot simpler and easier to resolve than what the court was just going through. But my client is Michael Lockhart,
okay, yes,
West Virginia. He's on Zoom right now. He's got
yes.
2 tickets that are on this calendar. And the state actually did serve me with the discovery, which I have.
Uh-huh.
The incident occurred in 2020, January 2020. The certificate of discovery does not include an accusation. There's no accusation. And I can't read the tickets. It looks like they were filed in city of Atlanta and not Fulton County. And if that's the case, we've got a real, a statute of limitations issue on both of these. I can't, the copies are so illegible, I can't make that out. So I wanted to come down here and talk with the solicitor. I thought it would be a lot easier to kind of discuss those issues.
And Your Honor, just to clarify, we did file the accusations, formal accusations yesterday. So you should be able to get them sometime today. You should see them on at the clerk's office. And the accusations do include the total. So that should, if you want to review and challenge that, that's up to you, counsel, but it doesn't.
Judge, I'd like to look at the accusations and maybe if we could have a reset and then we can talk about.
And then see, okay,
Because I still think there may be some questions and issues with it.
okay. I will reset you to January the 26th
Okay.
at 9 a.m.
And for me to access those 2 accusations, Judge,
Right,
that would be go on to the generally my paralegal kind of handles all that, but you're saying go on to the e-file site and we'll be able to access it there.
yes.
Okay.
And Your Honor, I would just file supplemental discovery. It was done yesterday, so I would have to file supplemental discovery today, so you can have access to the accusations.
So say by Friday, you could be able to get everything. Okay. Because she's gonna do supplemental today. I said Friday no later than Monday. It's possible.
Well, we'll make sure we pull it up before the next court date.
Certainly.
And then will we be able to do the next court date via Zoom, Judge?
You can, yes. The next court date will be, you will receive the link as well. Is that correct? You've entered.
I got the link this time here, but I just thought communicating all this.
No, this is great.
And I've been in another court, so I was trying to hear. So.
Right, so that we appreciate you doing that, but you will get the link as well. And if you want to sign on by Zoom like your client, you're free to do that as well.
Great, well, I appreciate that courtesy.
All right, thank you. All right, Mr. Lockhart, you're excused. Your case is reset to January 26th. That's on Michael Lockhart, because I have the 2 Lockharts. All right, next case I have is Travis Manuel.
Yes, Judge, I made my announcement. I believe the state was looking into it. We're waiting before the clerk came in.
Right, we were trying to see the answer to that $1 million question today. So, everyone in state court, we're catching up with the e-filing system. And so if you come down, that may be the best alternative right now until we work out the situation with the discovery being supplied to you. But if you don't have all of that, I'm obviously going to reset your case to January 26th as well.
Thank you. And if I could get the prosecutor who's on the case name or email or phone number in the chat.
Falk again?
Yes.
Okay, this would be Deputy Shelley Falk, F-A-U-L-K.
She's gonna email it. She did.
And you would be able to reach her after Monday. She's on leave this week. I don't want to crowd a Deputy McCutcheon with all of her cases while she's absent, but Monday will be here in a few days. If you reach out to her after that, you will be able to discuss the case with her.
Okay, great. Thank you so much, Your Honor.
All right, thank you.
That concludes my business. May I and Mr. Manuel be excused?
Yes, you may.
Thank you.
All right, thank you. Next case is Carlos Markland. Oh, I see that's reset.
Yeah,
That's
I'm
already
here.
reset.
Yeah, you're good. Yep, I'm here, ma'am. I'm here.
Okay, Mr. Markland, can you turn on your camera real quick? Looks like
Yes,
your
ma'am.
case is
Yes,
for today. Okay. All right, you're set today for a
Yes, ma'am.
final plea, Mr. Markland, is that correct?
Yes, ma'am.
Can't hear you.
Yeah.
I think you have a bad connection.
Yes, ma'am. Can you hear me?
I can now, but I need to find your camera button.
Yes, ma'am. I have the camera on.
You have what now?
I have it on. Can you see me? Can you see me now?
I'm getting every other word. I'm not even a full word. Your connection is very bad. You may need to sign off and sign back in. And make sure you sign in with audio and video so that I can see you. I cannot converse with you if I cannot see you.
Can you all hear me now?
We can hear you now, but I need to see you.
Yes, ma'am. Can you see me now? I have my camera on.
Nope, can't see you.
All right. And I've just cut it back on. Can you see me now?
Nope.
He probably needs to sign.
all right.
Just like
Probably
you said.
gonna have to sign off and back on again. Because it just
Okay.
keeps showing your name. And
Let
I
me
think
see.
it shows your name when you click on camera and not your face.
All right. Let me sign back in. Okay. Yes,
Okay,
ma'am.
we'll
No
come
problem.
back to you.
Yes, ma'am.
Okay, as soon as you sign back in, I'll see you.
Yes, ma'am.
All right, next case is Alexis Perry. Alexis Perry. Okay.
Judge, I apologize. I didn't hear you announce that. Good morning. This is
Good morning.
Attorney Patrice Helen from the Public Defender's Office. That's my case. I just would like Mr. Perry called to see if he's sitting in court. My notes state that last time he appeared in court.
He is here.
And Judge, can I have an opportunity to relay the offer in this case to him? If he could, or someone could put his number in the chat to me, he'll step out. I'll give him a call, Judge.
You have a cell phone with you?
Yes, Your Honor.
Okay, hold on a second. My litigation manager is gonna get you to write that there, and Ms. Helen will call you in a few seconds.
And Judge, I do believe this is going to be a plea. I just again want to talk to Mr. Perry and get more of his information. Okay, Judge?
Okay, that sounds good.
And good morning, Ms. Helen. May I ask, were you provided plea paperwork originally?
I do have plea paperwork. I will be filling it out and I will scan and email that to you and Ms. Redden today.
Right, Thank you.
Great. Ms. Helen is on it, so we appreciate it.
Thank you, Judge. Thank you.
All right.
So Judge, just give me a minute to speak to him really quickly. And as soon as we're done, we'll step back into the courtroom.
Okay, great. Thank you. You can
Thank you,
step
Judge.
out. All right. And she'll call you outside. Next case I have is Joshua Pierre.
Yes, I'm here, Your Honor.
All right. What is your announcement? Or first, let me ask, are you represented by counsel?
No, Your Honor, I have an attorney.
And who is that?
Yes, it's Mr. Mark Hill.
M-A-R-K-E-L?
M-A-R-K, and then the last name is H-I-L-L.
Oh, Mark Hill. I'm sorry.
Yes, ma'am.
All right. And is he running late? I'm looking, I don't see anyone on.
No, ma'am, he's not present here with us. We're asking for a continuance, preferably early February, for us to both be present here at the same time.
He has not filed an entry.
I'm not sure. I can't confirm that right
No, my clerk is telling me that. We don't have a February date, so it's gonna be January 26th.
She can do.
Or, okay, so we can reset it to February the 1st. Let your attorney know he needs to file an entry of appearance, and then he will get these announcements on the case. Your
Yes,
case
thank
is
you.
reset for February the 1st at 9 a.m.
Yes, ma'am.
All right. All right, thank you. You may be excused.
Your Honor, is the defendant being required to appear in person or virtual? Just wanted to make sure.
Generally, we're virtual. I mean, generally, we're in person.
State's understanding for these calendars.
So let me say this to you, Mr. Pierre. He is gone. We'll see what happens. Mike, you can make note of that. We'll let them know.
Thank you.
In person. All right, Jordan Randall or Jordan Randall.
Good morning, Your Honor. Lubanon here from Ms. Randall.
Yes.
Yes, what say the state on this matter?
Your client this is a status calendar, counsel. Your client should have received a letter from the Solicitor General's office indicating the plea recommendation. I'm going to look at it and make certain of that.
Let's see if you've received a recommendation.
Did your client receive that? Are you aware?
Are you aware of a recommendation or an offer?
I am not, Your Honor. I believe from previous counsel's argument as well, I didn't receive any type of notification for discovery. I just, during the whole discussion about that, I was going into Odyssey, in which there was a view document, and I purchased it right now. So
okay,
but albeit being about $4, so I went ahead and did.
I was just getting ready to ask you how much it was. About $4. Okay.
$4.11, but hey,
okay.
It's just a few pages of discovery. Well, a few pages is a citation, and apparently just a very small report. So that's where I am at this point, Your Honor.
Okay. So you're going to be requesting any additional discovery that you've just gotten today on January the 26th.
Is Ms. Randall here? Is she on the Zoom?
Yeah, I'm sorry. Is your client here? Good question. Thank you.
I have not seen her on screen. However, it was my client who notified me of just yesterday of
Oh, so she told you.
Right. And I wasn't sure if she had to be on there until I was hearing in on everybody who was present. So,
right.
But I right at this moment, I just wasn't able to get in touch with her. But I did speak to her yesterday as she was asking me about today. And it was just the notice that she had sent me for it. So I had to rearrange a few things to hop on here. So.
Okay.
Respectfully, the defendant's notice would have informed her that she was compelled to appear either in person or virtually. I don't have a copy of the notice in front of me. But Madam Clerk, does the notice say that the defendant has the option to appear virtually or in person?
I will go back and verify, but these are those original cases, and all of those original cases were in person.
So typically, counsel, the state would ask for benchmark because these cases were all reset from the initial calendar date, I believe in December.
Correct.
And the defendants were required to appear in person in December, and then the cases were reset to this date. So your client should have appeared.
Well, I mean, Your Honor, if that's the case, then I mean, I can, keep trying to contact her to see if she would log into this. And
she's not present, so the state would ask for a benchmark. She's not present. If you can contact her and have her to come in, the case was reset from a December calendar date. Apparently, your client was aware because she notified you, so she should be here because we can't move forward with anything regarding the case without the client appearing as compelled before the court.
And you
respectfully, considering that this is going to be continued, I was more than confident that it would be because I believed that there was no discovery whatsoever, or at least at the very least pre-try the case. I had filed my entry back in
December 5th is what the current Odyssey,
December
5th. And the state filed its discovery December 6th. And as you know, the misdemeanor discovery statute requires that we provide opposing counsel and or the defendant with a copy of the accusation, a list of witnesses upon whose testimony the accusation is based. But of course, the Solicitor General's office here in Fulton County, we provide our entire file to counsel, everything that we have in our possession, and then we supplement the discovery as other items become available to us, which we would do, of course, routinely in each case, including this case. Any video evidence that's or audio or other physical evidence that's available, we would provide that to you. But we have provided the initial misdemeanor discovery as the statute requires, and that was filed with the clerk's office on December the 6th.
Again, my client would, well, I mean, any of the filings, I would not have known about that until this hearing, when I was hearing in on all the discovery issues, which again, I just now looked it up and purchased it.
Saw that. Okay. Are you able to recess for a second to go call your client?
Yes, ma'am. I can certainly do that.
I would at least like to see your client, or she could sign on, or know that even though she was aware, she was noticed to appear.
Well, if Your Honor would afford me just at least a moment to do so, rather than issue a bench warrant, which I just feel that may be just at this, under these circumstances, where I haven't had any discovery or reviewed any discovery whatsoever. I just don't want to waste so many of the state's resources and going through the whole bench warrant process. But this isn't. I don't believe she's not on here intentionally just to evade the courts. I mean, she had hired me for this matter, and so I mean, Your Honor, if you would at least afford me a little bit of time to just briefly to try to get in touch with her to log on rather than.
Right, I would like to do that, since you stated that she informed you and is aware. And I don't believe attorneys say I'm going to appear and you don't have to. So if you could do that, I'll give you some minutes to try to reach her and ask her to sign on, give her the information, and then I will determine what I'll do at that point. So I'll give you about 15 minutes or so, 20 minutes.
Yes,
You'll still be here to see if you can reach her and get her to sign on.
Yes, ma'am. Thank you.
Okay, thank you.
Thank you.
Next case I have is Kaysen Walden. Kaysen Walden.
That is my case, Judge. Frank Gates with the Public Defender's Office.
Yes.
This case was transferred to me from former counsel Christy Wilson. And it appears that everyone is aware, everyone being the state, the court, and everyone is aware that Mr. Walden is actually in a 1-year residential alcohol and drug program at the Potter's House in Jefferson, Georgia.
Okay.
So I'm confused as to what exactly we anticipate will happen today, because I have no contact with him in Jefferson, Georgia. And I'm not making that drive. I'm just gonna, I know where Jefferson is. I used to go there all the time, but that's a grip. And I don't even know if they would even allow me to you just can't call them up. And I'm, even if I just arrive with COVID and everything else, I don't know if I could just walk in and see him, even being an attorney. So I'm just a little confused on what we are going to accomplish today.
Right, State.
Judge, I'm looking at the state's notes, and counsel respectfully, you said everyone knows. Has the state been made aware? I personally was not aware, but has the prior Solicitor General?
The note I said says the state advised they would keep their office open until December 19th, based on the information that was provided that he was in Jefferson, Georgia, in an in-house facility.
I don't see any documents in the file to that effect. I assume that someone orally made the state aware of that. But of course, I don't have any documentary proof that the defendant is actually in that location. But as far as this case is concerned, the state still does intend to move forward with the case. If counsel can at least provide the state some information as to when it is suspected that the defendant will be available to court, with the June 5th, 2021 speaking record. physically at that location?
He's on probation, and as a condition of his probation, he's in a 1-year treatment facility.
Or something, do you have any idea as to his anticipated release? The case is still open, Judge. We're just trying to find out when is he expected to be released? When did he enter? When is he expected to be released? When did he enter?
And it looks like the litigation manager did call and left a voicemail with the social worker.
That's why I'm not trying to be difficult. That's why I said I'm confused and I'm trying to get information. So the questions that you're asking, the legitimate questions, I just don't have because of the history of the case.
Gotcha. Well, it looks like at least as per the notes on the calendar, my litigation manager, there's a number there and the social worker and her name. So do you see that on the calendar, Mr. Gates?
Not on the calendar I have, but I think I did see it.
Oh, okay.
Indication on Odyssey.
Okay. Then that may be where Ms. Redding Franklin is getting that from, I'm sure. And if you could make that contact, since we're holding on this other case.
And Your Honor, perhaps if we have a date as to when it's anticipated that the defendant will be available to the court,
Then we can set it right.
Perhaps counsel can talk to his client and we can negotiate a plea in absentia. But we need to know exactly when the defendant will be available to the court.
Right.
If
You
he's
see
in a
that
treatment
706
facility-
number?
If he's in a treatment facility, my understanding is that me being able to talk to him is probably not gonna happen.
Not talk to him, but talk to this social worker here.
Yes, that's what's
Listed
gonna happen.
and see about that. If you can make that call to let us know that, then we can especially set it or at least know that we're gonna hold off for 3 months or 2 months. Just get us some information from that number, and the social worker there should be able to tell you his anticipated release date. If you can make that call. Franklin Redding, can you give him?
I can figure out what information.
She can give you that name and number.
Okay, okay.
All right, let me hold on that for a second. Because we'll recess, so I'm waiting on the other attorney. And I can, when I'm in recess, then you can make that call.
Okay, thanks, Judge.
Mr. Gaither. Next case is Gregory Michael, is it Wassey or Wassey?
Good morning, Your Honor. I'm here for Mr. Wassey. He should be available. He is on Zoom as well.
Okay, let's see.
Or he was, I'm not, oh yes, he's still on.
Okay. All right, in your announcement.
I am still in the process of pre-trying it with the state. I was emailed. I am trying to see if there is a video in this case. I do not see one. I've been emailing with Miss Falk. I emailed with her right after Christmas or right before Christmas. I haven't heard back. I'm assuming now it was because she's on vacation. So when she gets back from leave, I anticipate trying to work out an offer.
Okay.
And Judge, again, counsel, I'm looking for you. Oh, Ms. Miller. Yes, my name is Michelle. I'm standing in place of Ms. Falk. She's on a family leave, emergency leave, so she's been out this week. Did she indicate to you whether or not she had obtained the video?
She did not.
I don't want to waste time with that, but if you would contact me, I'll put my number in the chat. And then we can discuss the case and a plea offer.
Okay, thank you. She indicated we started an offer, we started discussing the case, but I haven't heard back from her. So we will just go from there.
She had emergency leave, so I'm certain she did. Perhaps it might be best, Judge, then to reset this since Ms. Falk has already began pre-trying the case with Ms. Miller. And Ms. Falk is actually out of state now, so she's not in the office. I expect she'll be back next week.
Okay.
Reset it then, Judge, to
Yes.
January 26th.
Okay, let's do that. We'll reset it to January 26th, Ms. Miller.
Okay, thank you, Judge. Will we receive notice in the mail or is this our notice?
You're going to receive the link again, I think. Yes.
Okay, that's all I was wondering.
Again. Yes, thank you. All right.
Okay, thank you, Judge.
The availability of the video to see if you've already obtained it. If so, send the link to you. You filed an entry, so your email address should be on your entry.
Should be on the entry.
Yes, sir.
All right,
Okay.
thank you.
Thank you. Are we excused?
Yes, you're excused. Thank you.
Thank you.
Mr. Williams, attorney for Devin Williams.
Yes, I'm here, Your Honor.
Yes, all right. What is your announcement, sir?
Your Honor, can we sound for Mr. Williams in the courtroom or on Zoom?
Yes, Mr. Devin Williams? Devin Williams. Not in the courtroom.
Your Honor, I know his previous notice was returned. I tried reaching out at the forwarding address and have not yet been able to make contact with Mr. Williams.
Okay,
Judge, the state would ask for an FTA and a bench warrant.
all right, we will issue that bench warrant and we'll go from there, Mr. Murphy.
Thank you, Your Honor, and thank you for making my announcement.
Yes.
I'll continue to try to reach him. May I be excused?
Yes, you may. Thank you.
Thank you.
All right. And next case I have is Charles Waters. Charles Waters.
Nicole Jones from Mr. Waters. He is online as well, Your Honor.
Oh, I see it.
I have not received discovery or anything in this case, Your Honor.
Okay. And you filed your entry when, Ms. Jones?
In December, we did a waiver of arraignment and the discovery all at the same time, and they have not filed discovery either. I looked online.
Okay.
Judge, I am looking now, and our discovery, the state filed discovery on December the 6th for Odyssey. It shows that it was filed by the state on December the 6th of 2022 council.
Do you see that? December 6th? The state's discovery was filed.
I am looking on the Fulton County website at this moment in time, and there is no discovery filed. The only thing that was filed has been my entry of appearance. And I'm going to say what the previous attorney said, according to the statute, it's not just filing, it is filing and serving. And if you filed and you didn't get my entry of appearance, you would have had to serve my client, and he did not get any discovery.
Okay.
It's showing filed through the Odyssey system. Now that you have made your entry was on December the 7th. We filed it on December the 6th. Now that you're in the case, as we said before, if you're on the Zoom council, you should be able to access that because you filed an entry into the case. If you have Odyssey, it shows on the Odyssey that it's
Looking at Odyssey, and there is no discovery filed in the clerk's file, number one. And number two, even if you go through the e-file system, according to the statute, it is file and serve. So if you filed it, that's great. Did you serve it upon my client? Because my client does not have it either.
Judge, again, we will just state what we said before regarding to the service system, so defendant can come down and it's available for the defendant to copy, inspect, copy, and photograph as the statute requires.
All right, since you do not have the discovery, Attorney Jones, I'm going to reset it to January 26th so that you can obtain that discovery from the state in some manner and then be able to pre-try with them to see if they have an offer available.
Your Honor, if you go, and I'm not, just for the record, so this is on the record, if you look in the clerk's file, Odyssey on file,
yes,
the only thing that has been filed in here is my waiver of arraignment. And I know they say they have their scanned discovery, but you have my waiver of arraignment and the arraignment itself. They are required to serve the parties. Unless they can prove that they served the parties, filing it is ineffective.
Gotcha. All right, well, I'm going to reset it to January 26th so that that matter can be addressed. My litigation manager is looking at the docket as we speak. Looks like the documents are there for you to access. And hopefully we can get through this or beyond this to find out again what we need to do about the service issue. And any appropriate motions that you need to file because you're stating that you were not specifically served with the documents, but they are available for viewing, accessing, and obtaining them through the website. Looks like they were filed again the day before your waiver and entry. Is that correct? They were filed on the
Yes.
6th, your waiver and entry was filed on the 7th. So I understand what you're saying, but to let you know that there, I will reset it to give time for the state to get it to you in the form that they envision, or you can file motions if you haven't gotten it before the 26th. So you want the disposition to be on that day.
And just for the record, I understand, Your Honor, and I just want to put this on the record so the state will also know. According to Odyssey, you can only view the first page. After that, you have to pay 50 cents per page to even view. So if they did not do, which when you do file, you have to press file and serve. If you do not do file and serve, that means the defendants or anyone else cannot see anything without incurring a cost on a criminal case, which is unconstitutional.
I just heard something different. So there's a file and serve button on there?
Yes, ma'am, you have to press file and serve, not just file.
Okay. Appreciate that information. Thank you very much. All right, your case is reset to January the 26th at 9 a.m. And hopefully we'll be able to resolve it at that time. Thank you so much for your time today.
Thank you.
May we
Judge.
be excused, Your Honor?
Yes, you may be excused. Thank you.
Thank you. Have a great day.
You too. Are there any persons in the courtroom whose names I did not call or didn't hear your names called?
Judge, yes, I was walking out just to make that phone call,
Mhm.
and I was checking in the courtroom. There's a young lady here, and her mother just told me that they were in courtroom 6C. And since it was overcrowded, they direct y'all to come here, and her name is Orca Williams. And it's a huge deal, they got that 6C.
That person on our calendar, we don't have that down.
She's not, what happened, she said they were supposed to report to 6C, and they did, and then the 6C told them to come here. So I'm just thinking everybody will actually get here.
Trying to figure that one out.
I'll follow.
She's gonna look it up real quick to see, so hang on for a second.
I believe that we're waiting for your comments. She was pre-tried your comments.
Yes.
Okay.
I know we have position 3. We were holding for Attorney Frank Hicks.
And number 12.
And 12.
Good morning, Your Honor. This is Attorney Stephen Smith. You mentioned Frank Hicks. He's an attorney with my law firm.
Yes.
And was that Bruno Delva that you mentioned?
Yes.
Yes, Your Honor. I am present, and so is Mr. Delva.
Okay, Mr. Delva, let's see. Do I see Mr. Delva?
Yes, I'm right here.
Oh, okay. There you go. All right. Yes. What is going to be the disposition for this case?
Your Honor,
Announcement or Mr. Stephen?
I was present during the discussion in regards to the discovery. It appears as though we have a similar issue. My announcement was we have not received the discovery, so it may be in the e-file. So we will certainly look into that if it's in fact there. I would like to provide the state my email address so that she can forward me any sort of plea offer so we can look from that angle as
Okay. And so you'll handle this for Mr. Hicks, either of you can be reached on it. State, let's get Mr. Stephen, is it Stephen or Stephen?
Stephen.
Stephen, get his email. Can you put that in the chat real quick, please?
Yes, I can, Your Honor. Who am I addressing that to?
Monica Franklin Redding, our litigation manager. I'm not for sure if it has, it has Orca, M. Franklin Redding. Do you see that?
I'll send him a message directly.
She's getting ready to send you a message directly. So just respond with her with your email and we'll put that in.
Very good, Your Honor. And can I get the assigned prosecutor to the case, the name?
Is this Deputy Falk?
Yeah.
Okay.
I'll send all that to him.
She's going to put that in the chat to you as well, to spell her name for you.
Very good. And can she also put in Deputy Falk's email address in that message?
Okay, she will do that too. Very
Thank
good.
you, Your Honor.
Your Honor, just on the record, they did file discovery for this case on December 5th, 2022. Attorney Frank Hicks did make an entry of appearance way before then on November 10th, 2022. So if he does go, are you able to access it through the electronic system, or are you also having issues with that?
I think he said he was able to access it, correct? You see it now on the system on Odyssey. Is that correct, Mr. Stephen?
I have not attempted to access
Oh,
that.
you have not. Okay, you have not. Okay. They said that the entry was filed November 10th and they filed discovery on December 6th.
Okay, very good. Then we'll look into that.
That's it. Okay.
And
Judge,
Yes. Who's speaking?
oh, I apologize. This is Carlos Markland. I just wanted to notify you that I'm
Oh, you're
ready.
back.
Yes,
Okay,
ma'am.
still. All right. Hopefully you can get your camera going.
Yes, ma'am. Can you see me now, ma'am?
Yes, we can see you.
Yes.
Good.
Good
Okay,
morning,
hold
ma'am.
on 1 second. I'll get to you in a
Gladly.
second. Okay, thank you.
Your Honor, I apologize. I didn't mean to interrupt you. Lubin
Yes.
on here for Miss Jordan Randall. She is on right now. Again, I just want to let you know that she had informed me about this particular hearing yesterday, and she has had some severe technical issues getting on, which proves when I was calling her, it kept going straight to her voicemail. So,
Mr. Ann, I don't mean to interrupt you, but before my case is dealt with, Your Honor, I didn't receive a new court date, and if you said it, I missed it.
Okay, hold on a second. Have you sent the chat? Oh, you do have the chat, correct?
I do have the check.
Okay, and so we're gonna reset your case to January 26th as well.
Okay, and is that at 9 a.m.?
Yes, 9 a.m.
And what sort of hearing is that set for? The similar one, a status?
Similar one status, correct.
Thank you, Your Honor. And that's all
All
the
right.
business I have. We be
Thank you.
excused.
Yes, you may.
Thank
Thank
you.
you.
Is that in person or virtual?
That will be in person again, Mr. Stefan, because this calendar was noticed for in person. We're trying to go to that, back to in person. So if you and your client could appear in person, especially if we're taking a plea, that would be the preferred method for January.
Very good. And just, I'm covering for Mr. Hicks, so it'll be Mr. Hicks for one of our other associates, most likely.
Okay, got you. All right, thank you so much.
I
All right,
might
thank
not be able to show up on the 26th. I stay in Florida. So if I can't make it, is there something, can I reschedule or something? I'm not sure if I can make it around that time.
Mr. Delva?
Yeah.
No, your client, Mr. Stefan, is Mr. Delva.
Your Honor, while you're considering that, because he does live in Florida, we are asking for his appearance to be waived for that status and for the attorney to appear. Of course, if it's going to be a plea and the court requires his presence there, unless we can do a plea in absentia, then we would have him present.
No, we can do a plea in absentia. I'm looking at the state to let them know that Mr. Delva lives in Florida.
Judge, the state would not be opposed to, if the court is so inclined, for the defendant to appear via Zoom. The state much prefers the virtual as opposed to absentia. Of course, we prefer the in-person, but between absentia and virtual, we prefer the virtual.
Right.
Only issue would be counsel, Mr. Stephan, if you would let Mr. Hicks know that we would need to speak with him, get the plea resolved, get the plea paperwork sent to him so that he could then go over the plea paperwork with the client and then send it back to myself so that I can provide it to the court so that we would be ready to present the plea with the defendant appearing virtually.
Right.
That sounded like a lot, but what I was saying, counsel.
Right. Do you understand, Mr. Stephan, what you're saying? If it's going to be a plea, we need to do as early as possible so we can get the paperwork back and forth to Mr. Delva if we're going to allow him to appear via Zoom, because he will still have to sign the original plea paperwork prior to that date and make sure that
I'll make note of that. And was that Miss Faulkner speaking?
No, Miss
prior?
Falk is out. She is out to next week. That was Deputy McCutcheon filling in for Deputy Falk.
I tell you what, I will put my email in the chat.
Okay.
I anticipate that Ms. Falk will be back next week, but if we think that we can resolve this and get it.
Right, she's willing.
I'll go ahead and.
She's willing to resolve it prior to, if you can. So she'll put her email in the chat as well.
I sure will.
Very good. Thank
Okay.
you, everyone.
All right.
Business
thank
we have.
you.
Maybe. All right.
All right, thank you. All right, let me go back. STEPHEN. I think she has it.
Thank you.
Right. She was keeping up for us, so good. Yes. Let me go back to Ms. Randall. Is that correct?
That's correct, Your Honor.
Good
And
morning. Good morning. And tell me your name again.
Jordan Randall.
Okay. All right. Thank you for appearing, Ms. Randall. We were making sure that you're aware and to not want to issue a bench warrant for your non-appearance. So
Yeah, I just always, my phone just doesn't like Zoom. It never has.
okay. All right. So we're going to reset your case till January the 26th.
and Your
So
Honor,
that
I'm
we
sorry.
can, so that we can see what the recommendation is and to make sure that we're ready to take a plea or proceed in some other manner on that date. Is that good, Attorney Lubin?
Yes. Would that be virtual as well?
If it's going to be a plea, we prefer that to be in person.
No, otherwise, we could do-
Otherwise, you can do virtual.
All right, thank you. And if I may ask the state, who would be assigned to Ms. Randall's case?
And that would be Deputy Falk, Faulk. I know we're both laughing at the same time. Yes, but Ms. McCutcheon is trying to fill in her absence. We believe that she will be back next week. We're just not for sure exactly what date, I don't believe.
I'll stay in communication with Deputy Falk then.
Okay, that'll be fine.
If you have any questions, you can reach out. She's had a family emergency.
Yeah, it's an emergency, so we're not exactly sure what date. So, if it goes past Monday or Tuesday, if you want to reach out to Deputy McCutcheon at that 4800 number, you can call, leave a message, and she will return your call.
Certainly. All right,
Okay.
thank you, Judge.
All right, thank you.
May
Have
we
a good
both be
day.
excused.
Yes, you may be excused. Thank you, Ms. Randall. All
Thank
right, thank you.
Thank you. Good evening.
All right, you're welcome. Anyone else that we're holding on?
It was me, ma'am, Carlos Markland.
Oh, yes, Mr. Markland. Let me come back to you. Mr. Markland, you're representing yourself or do you have counsel?
I'm representing myself, ma'am. I'm put my camera on. I'm representing myself, ma'am. I was just coming to. I really just need to inquire on how I need to pay my fee, pay the fine, because if you remember, I'm going into the Air Force. I leave into the Air Force on Monday, and I'm trying to pay it so I don't have to be on probation or anything.
So you're trying to take a plea and pay your fine?
Yes, ma'am.
Okay.
Judge, again, this case was reset, so the state had anticipated that the defendant would be in person. Are you aware of the plea offer that was previously given to you that was 10 days to serve, suspended upon payment of the $500 fine, plus the associated costs and the open container fine of $200? Mr. Markland, were you aware of that?
Yes, ma'am. I do apologize. I did not know that I had to come in person. Please forgive me. I did not know that. I am aware that I have to pay the fine, and I'm ready to pay the fine today. Even if I have to come downtown right now to pay the fine, I will come down right now and pay.
They were going to allow him to take care of a wife with me today because he was.
Because I'm going, so you're leaving town on Monday. Are you able to make it to the courthouse today?
Yes, ma'am. I'll make it to the courthouse today to pay the fine. Yes, ma'am. I sent over the paperwork to Ms. Falk regarding my deployment for Monday. I did not know that I had to come in person unless I would have, ma'am. So please forgive me, but I will.
No, I think I will accept some miscommunication as well, because I'm hearing from my litigation manager, we were aware, and I do vaguely remember as well. So what time would you be able to get to the courthouse today?
I will be able to get down there no later than 12. I will head down there now.
Well, if you could.
I can see if he's able to pay
What about the paperwork? Yeah. All right, so we're gonna allow you to come down, get here as quick as you can, as safely as you can.
Yes, ma'am.
And when you get here, you need to go to.
Would it be better for us to come back here to the courtroom?
because we're flooded upstairs. So
I'm sorry?
Yes, because we're flooded upstairs. So we are not accepting.
Judge, I can report back here then. whatever
Okay,
time.
so you're saying by 12?
Yeah, I'm going to be frank with you, ma'am. I am at a gas station right now by the airport. I will drive directly down there now. So
that would be even better.
put it in parking. I will be there no later than 11:05. I will come right now.
Okay, well, we will be here, or if we not, we'll come back to the courtroom. Just don't speed and
Yes,
get
ma'am.
there as safely as possible. And
Yes,
we
ma'am. What's the
will-
courtroom number, or what? Where do I come to?
G33.
G33. Yes, ma'am.
Okay,
And the location is the Fulton County Court on
Fulton
Pryor
County
Street.
Courthouse, 160 Pryor Street.
Yes, ma'am. There we go.
And you're coming to State Court. G33 is the courtroom. And I believe in the chat, can you see the chat?
Yes, ma'am.
All right, Miss Franklin Redding is putting that information in the chat for you as well.
No problem at all. I'm going to see you soon, ma'am.
Okay, all right, thank you.
Thank you.
All right.
All right.
Good morning, Judge Mincy. Denise Riley for the state.
Yes.
I believe you have a second calendar, the Orca B add-on show cause. It's one position, Demetrius Adams. It's represented by Mr. Rafoff.
Yes, Your Honor, I'm here, and Demetrius Adams is here.
Okay, thank
Both
you.
here.
All right, and I am looking at this case and what's the,
Your Honor, this case was placed.
Okay, go ahead.
On a show cause calendar by Judge Law. The agreement was that if Mr. Adams showed proof of either returning the vehicle or paying a $1,000, which was the surety amount, to the title pond, that we would null pros the case. And I believe Mr. Rafoff has a receipt.
Okay.
Yes, I have the receipt. The problem is it's on text. And if somebody here could email the text to somebody, we could have it. But yes, I have it. I could show the court, but I don't know how to email it.
Well, it would be the state that would need to see it.
I think we're gonna help him with the technology here.
Okay.
So hold on a second. I think she's gonna email it to herself and then email it to you.
But the letter seems to conform to what Judge Law said, as far as I can tell.
Okay.
The person who wrote the receipt was instructed to give him a release, and it seems.
Right.
And the state did confirm with Mr. Stamberger at the title pond that it was received. So upon me seeing the receipt, I would be tendering that null pros.
Okay.
Ms. Smith.
All right.
Yeah. Okay. Just one document.
Oh, yeah.
you send it to an email? Or can you email it to yourself? Can he email it to himself and email it?
I'm going to recess for a second while we're sending that text message / email receipt. So I'm going to recess for 3 to 4 minutes.
Yeah, I have made contact with the Potter's house.
You can have a seat.
They confirmed that he is there in Jefferson County. However, there's a, HIPAA violations and their own client, patient doctor privilege. They can't give me the person on the phone could not give me the details of when he entered and released it, but transferred the call to his social worker. She was unavailable, so I left a message. Matter of fact, the person on the phone confirmed that Madam Case Manager just called yesterday.
So they were aware.
So now I have a name, I have the number, I will keep making calls. So at least if we can at least reset this, just give me some time to make some calls. And if I have to make a personal appearance now, I can make a personal appearance knowing I'm going to see somebody. But just what I was trying to say earlier, just me showing up to Jefferson County first time, they don't know me.
Yeah, they're gonna just turn me around.
Exactly. And it's not even a felony. I hate to say it, but it's not even a felony. So now they would just turn me right around.
Mhm. So you think January 26th is good?
That should be enough time for me to make contact with somebody.
Let's reset January 26th. That's
Yeah,
okay.
let's do February first.
Oh,
Yeah,
do
it's just,
February
yeah,
1st, okay.
yeah, 'cause I'm,
Okay. So we'll do February 1st, and that's on Case and Walton. And we'll find out his availability of when we need to reset for free or what we're. Yes, sir. All right, it's February 1st.
okay. Thank you.
Okay. Yes.
Received an announcement on position one.
Okay.
You can set it, set on a status one, final plea calendar. I've already sent the defendant over forms of waiver of rights, that form as well. In order for him to come in person and plead and then pay the fine in full, because that's part of the offer.
Gotcha.
So that he can avoid jail time.
That we were setting to February the 8th, which is the final plea calendar at 9 a.m. and for in-person appearance.
Your Honor, may the defendant be excused?
Yes, defendant may be excused.
Lori.
Yes, I'm here, Your Honor.
You hear that? We're resetting your case to February the 8th at 9 a.m. and you're to come in person to the courthouse to G33 so that you can pay your fine.
I also did have a question. I am able to pay the fine today, given the fact that the court is still open. If they're open, I'm not sure what time the clerk's office closes. I am able to do that today as well, so that I don't have to waste anybody's resources or time, for rescheduling.
Your Honor, I think it'd be most effective if he pleads and subsequently immediately pays the fine. Because
Right, if you pay the fine today, but take the plea later, that will not help us. It'll be more confusion, so we prefer you to hang on to that money and pay the fine on the day that you take the plea all together on February the 8th.
And Mr. Mulari, it will not suspend your jail time if there's some gap. It's an immediate payment of the fine in order for you to go jail time.
So there is no jail time once I pay the fine.
Correct.
And that offer is still there on the 8th.
Right, we want to do that on the 8th, okay?
Okay, perfect. Thank you so much.
All right, we'll see you in person on the 8th.
May I be excused?
Yes, you may be excused. Thank you.
All right, thank you. Y'all have a good day.
You too. All right.
Judge, that was the state's reason for wanting this to be in person so that the fines can be paid in Stanter.
And then you know that you're, yeah.
Yes.
Yeah, I do get it. I don't know if we need to change the announcement or what.
I think what happened was not reset the initial for them to come in, but it was not walked through once it was reset to establish that to tell them with the reset.
Right.
To come in person as well.
I would give my recommendation that on these in-person calendars, if they're reset, if all reset dates should be in person.
It should be in person as well.
Because then at the status, the hope is that we're calling it a status, but we're hoping that it will be a calendar.
Understood.
Yeah, that's
Yeah,
good.
I agree.
Yeah.
I agree.
Yeah. And I know, my litigation manager will remind me. So we don't have to remind me too. Good. All right, Ms. Helen, do we know where we're?
Yes, Judge, we're ready on Mr. Perry, whenever you are.
Okay.
So Judge, when I actually stepped out and spoke to Mr. Perry, I just want to state that I inherited this case. So I stepped out and, or Mr. Perry stepped out and we caught up. On the December 5th Orca calendar date, Mr. Perry had provided the state with a complaint against the Atlanta Police Department. In reference to this case, the state announced that it was going to investigate that complaint, and then by this court date, see whether or not they were going to null process it. I don't know if that investigation has been done. I provided that complaint to the state. If a null process is not being offered today, again, I've spoken to Mr. Perry. He is not accepting any appeal from the state. So we are going to be requesting a bench trial. I've already entered in my appearance. I just was entering in just now so that I can get the video discovery as well. I believe that's also another reason why it was rescheduled. So Judge, I just entered my appearance. I will follow up with the state for those videos to review it, but we'd like a reset to a bench trial for Mr. Perry with this case.
Right. Any word from the state or any?
Yes, Judge, the state had made an offer. I am in receipt of the letter that Ms. Helen emailed to me on yesterday. I did respond to her indicating that I had received it, and once again reiterating the state's plea offer. The state does not intend to move forward with the null process of the case. So we will be ready when the case is called. And Ms. Helen, I will have an investigator check on the availability of the video and provide that to you as soon as it's made available. And I think after I received your email last night, I'm just going to confirm, I think I requested that last night after I responded to you, because I anticipated that we would need that.
Excellent. Excellent. So that is correct, Judge. I have entered in my appearance. As soon as we get that video footage, I'll be able to give that to Mr. Perry, but we do want that bench trial schedule date.
Okay. So March 22nd. All right, that will be March 22nd.
Understood, Judge.
March 22nd at 1:30.
And those are in person, correct, Judge?
Those are in person, correct.
Your Honor, would that be you presiding over the bench trial, or?
I don't know yet. We're meeting next week to work out our logistics as well. I'm not sure just yet. But we do have the date. That's progress. We'll fill in the judge as we go. But certainly March the 22nd, 1:30.
And Ms. Helen, I will look into the video for you, but it would be Deputy Falk would be the attorney that you would be reaching out to.
I apologize. It was a little low. Who is that attorney?
Deputy Shelley Falk.
Ms. Falk. Okay.
Is it Michael? Is your Michael?
I couldn't get it to turn on.
Oh.
I tried.
And thank you, Judge. And I just wanted to verify that the date is March 22nd at 1:30 p.m. in person in that courtroom G33.
Yes.
Okay, Judge. And again, I have entered in my appearance. I think we're working on the video, so I should get those soon. So I just want to say thank you, Judge.
Okay. Sounds good. Thank you so much. Anything else?
No, Your Honor.
Okay, and your client will letting him know he's dismissed. Thank you.
No, he needs to have a seat.
And I have requested Ms. Helen the video.
What? He needs to have a seat to sign the acknowledgement order for a bench trial.
Oh, we're going to have you to sign an acknowledgement order for that bench trial.
And once he signs it, I will then sign it as well and send it back to Ms. Redden.
Right.
Is that the waiver, Ms. Redden?
Yes, that's the waiver. All right, so hang on for a second. You can sit there. Yes.
Thank you.
All right, thank you. All right, thank you, Ms. Helen. Appreciate it.
Thank you so much, Judge. I believe that was my only case. Can I be excused? I'll remain on the line, but
yes, you may. Thank you.
Thank you, Judge.
Okay, I'll do my probation case. I don't have anything else that I need to take up before then.
Your Honor, if I could, on Paris Johnson, on Demetrius Adams on the show cause calendar, we provided that paperwork. I think it's been received. And so we would ask that he be excused.
We got to sign the no process on Demetrius Adams. So that has been done. There we go.
Okay.
So, all right, thank you. That case
Can you get it
is handled. And thank you, Ms. Riley.
Thank you, Your Honor. That is my only matter. May I be excused?
Yes, you may. Thank you.
Thank you.
All right. Okay, probation. All right, I am calling, this is case number 22 CR 002743Y, State versus Jasmine Worthing. And I have probation, state your name for the record.
Miss Harris.
Okay, Ms. Harris, and what would you like to present to the state today?
That's the case that you did last week on the SAP with me and Mr. Barnes. We just need you to sign this petition so we can send it over to the jail.
Okay, great. I will do that. On the petition for modification, okay. Track me down, correct?
I did. I used to say you and Judge Monroe and Judge Law.
Right. 2023.
Right. It'll take us to February to remember.
There. There are 2 copies? No. Yeah.
So small. We'll make a copy, please.
Like this. Okay.
Everyone ready to consolidate the calendar?
Yeah.
This is the Orca A status. I am going to, since our calendars were off, I'll also announce the last name. Does that help? Okay. Position number 1, Valori, reset final plea. February 8th at 9. Position number 2, Davis. We had a return to sender. He was FTA bench warrant. Position number 3, Delva, reset status, January 26th at 9. Position number 4, Hines, reset status, January 26th at 9. Position number 5, reset status, January 26th at 9. Position number 6, Lockhart.
Did he ever appear?
I will have hold for the attorney.
No, he appeared, it's his attorney, Attorney Stephen Coxon.
Yeah, we had hold for report.
We'll have hold for a report.
But then, but then I wrote down plea January 26th.
I don't have anything.
I don't have anything.
I don't have anything.
Right. I have January 26th for Michael Lockhart, but I didn't have anything for Jerry Lockhart.
Correct.
Well, Judge, I remember you asking him, you said, you got 2 cases. He said, yeah, but.
No, that's Michael Lockhart. Michael Lockhart has 2 cases.
He appeared, and Penny appeared.
I believe Mr. Jerry Lockhart's here in person.
But Michael Laney is not.
Correct. Jerry Lockhart, where are you? Okay, Mr. Lockhart, have you contacted your attorney? Are we still waiting on him?
Yes, he's in Covington and another case, he's supposed to.
Stand up.
He's in Covington and another case, he's supposed to be coming here right after his other court case in Covington. So.
And Your Honor, just his attorney did file notice of conflict for today's.
Oh, he did for today?
Yes.
Oh, I
So-
get it. Okay. So we can read.
I don't know about him coming from Covington. Right, so we're gonna go ahead and reset you, Mr. Lockhart. Come up, please. Since your attorney did file a notice of conflict,
Yes, ma'am.
and I'm sure sometimes we hope we'll get out of court much sooner, but that doesn't happen, and he's coming from Covington. So that's at least an hour or so drive, I believe. Depending on the traffic and good old.
I stay that way, that's why I'm kind of irritated, it's my 3rd time. I'm very irritated. I'm very irritated.
Wow.
Yes, ma'am.
You need to make sure your attorney understands your displeasure with it. Sometimes they take on a lot of cases and we're not in control as attorneys of those court dates. And they all seem to happen on the same date for some reason.
Yes, ma'am.
Let him know to reach out to the state to have some pre-trial discussions.
Yes,
regarding the case. And, you know, this is your 3rd time, and I apologize, your attorney has filed the right paperwork for that, but you're right, and you drive from Covington, but he doesn't. And see if he can have some discussions with the state.
So are they gonna hit him up for the recess? Are they gonna contact him? I'm confused.
No, they're not gonna contact him, he needs to contact them.
Okay, so they're gonna contact, he's gonna contact them and then they're gonna reset them and then they're gonna hit me back? I'm confused.
No, you need to tell your lawyer about the reset date.
Oh, I need to tell him.
Yeah, to tell your lawyer about the reset date and he'll reach out to the state on whatever they need to talk about.
Okay.
And then kind of let your lawyer know that you're a little upset that you keep spending gas driving to Covington, waiting for him to come to court. And that, you know, he needs to try to make sure he gets your case handled.
Yes, ma'am.
So that you don't go through a 4th reset because of his conflict.
Yes,
He obviously has a lot of cases.
Yes, ma'am.
And a lot of court dates.
Yeah, it's
You know, at the
understandable.
beginning of the year.
Yeah, it's life, it's understandable. Yes, ma'am.
So just kind of let him know in a nice way that you would like to get it handled.
Your Honor, if you'd like to just set it for the final plea calendar so that when he tells it, get the report on complete, that'll prompt him.
Let's do that. We'll kind of help you out a little bit here. And set it for the final plea calendar. That's February the 8th, to give it a little time, and then that will be a plea calendar
Yes, ma'am.
instead of a status calendar.
Okay.
Help a little bit. So that's correct. I did say that correct, did not correct. Okay, so we're gonna set it for the final plea calendar on February the 8th, okay?
Yes, ma'am.
Unfortunately, you do have to come back in person.
That's cool.
Hopefully, one more tank of gas.
All right.
But yeah, we'll reset it for February the 8th, Mr. Lockhart.
Yes, ma'am.
Okay?
All right. My excuse or?
Yes, you're excused. Thank you. Let your attorney know.
All right.
All right.
Okay. Position number 7, Michael Lockhart,
reset status January 26th at 9. Position number 8 is also Michael Lockhart, reset status January 26th at 9. Position number 9, manual, reset status January 26th at 9. Position number 10, Markin, defendant en route to courtroom. Position number 11, bench trial, request for a bench trial, March 22nd at 1:30 to appear in person. Position number 12, Pierre, reset status February 1st at 9. Position number 13, Randall, reset status January 26th at 9. Position number 14, Walden, reset status February 1st at 9. Position number 15, Wasi, reset status January 26th at 9. Position 16, Waters, reset status January 26th at 9. Position 17, defendant FTA, attorney was present on Zoom. However, there is a bench warrant issued for the defendant's FTA.
Quick question. What was, just so I make sure my,
Yeah, I'm missing 2 positions. I guess that's,
was there a Wanda Gail Jackson on the calendar?
No, that was removed.
That was removed. Okay, that was removed. All right, and then
and position 12, what was the date?
Position number 12, reset status February 1st.
Is that
at
for
9.
Perry? Oh, I'm sorry.
It's for Pierre or Joshua Perry or Pierre.
And then
IERRE.
And the date for Alexis Perry?
Alexis Perry is request bench trial, March 22nd at 1:30 in person.
and then my case, 15, Case in Walton, you said February the 1st or January 26th?
February 1st.
February 1st, got it. Okay, just want to make sure. And was there a Gregory Michael Wasi on the calendar?
Yes.
Yes.
Wasi is position number 15, reset status January 26th.
Okay.
My numbers are off.
Yeah, mine are off too, because I didn't get, because number 5, the original number 5 was removed. Got it. Okay.
And for Mr. Devin Williams?
Devin Williams, FTA bench warrant.
Understood.
And then there was one position on the Orca B add-on show cause. That case was null pros for Adams.
And he's ready. We still have a 1 o'clock calendar with Kevin Corrales.
I have not heard from Judge Law as of yet. I will phone her once we break.
Is Judge Law covering that or Judge Mincy?
Judge Law was the one who special said it, so I reached out to her.
You say Judge Law.
So what kind of student, you know, we're waiting on, Mark. Okay.
You need to see it.
Give me a second. Ms. Williams, I'll still be with you in a second, okay?
All right, we will recess until Mr. Martin arrives for a plea. Thank you. Back on my, hold on. Yep. Back on screen here. All right, this is State versus Carlos Martin, 22 CR 00714. This is State versus Carlos Martin, 22 CR 00714. I understand that you wish to plead guilty today to certain charges. The first one being driving in a circular course lane drag and possession of open container of alcohol. Is that correct?
Yes, ma'am, Your Honor.
Okay, and I'm going to first swear you in. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am, Your Honor.
Okay, good. All right, and so state, what do we have as the offer in the plea for today?
Judge, the state is offering a plea of guilty to the driving circular course, excuse me, circular zigzag course, a fine. Our recommendation is 10 days to serve in custody. That 10 days suspended upon a payment of $500 plus the associated court costs.
All right.
As to the possession of open alcohol container, the state is recommending a $200 fine plus the associated court costs, for a total of $700 in fine plus court costs. And on the reckless driving, the state will no prospect on a plea of guilty to the other two charges. And Judge, the state makes this recommendation based on the defendant's representation that he is prepared and expects to, in the next few days, be, I guess, deployed is the word, into the United States Air Force for military duty. So taking that into consideration, we're making this offer to the court.
All right, great. Is that your understanding, Mr. Markman, of this plea today?
Yes, ma'am, Your Honor.
And you intend to represent yourself, is that correct?
Yes, ma'am, Your Honor.
Right, and you understand the consequences of representing yourself, that you're to know the rules and laws of the state of Georgia, correct?
Yes, ma'am, Your Honor.
All right, and you're doing that freely and voluntarily, correct?
Yes, ma'am, Your Honor.
All right, in order to take your plea, I'm going to ask you a series of questions. And first, let me ask the state, do you stipulate to the venue identity and factual basis?
Judge, since the defendant is proceeding pro se without the assistance of counsel, I would like to put it on the record for the court as to what the state would expect the evidence to show briefly.
Okay.
Yes, the state would expect the evidence to show that on or about August the 9th of 2020, at the location of 400 Edgewood Avenue, in front of the Exxon gas station at that location, located in Fulton County, an APD officer observed the defendant laying drags, or as we say, driving in a circular zigzag course at that location. The officer then conducted a traffic stop on the Chevrolet pickup vehicle, immediately placed the driver, identified as this defendant, Carlos Marklin, into custody. The officer then observed an open bottle of rum alcohol sitting on the front bench seat next to where the defendant had been sitting, which was within his immediate arrest. Which was within his immediate reach, the open container. The defendant was then taken into custody and the vehicle was impounded, subsequent incident to his arrest. And that's the factual basis of the case, Judge.
All right. All right, and again, Mr. Martin, you are pleading guilty to the two charges with a no cross of the reference. Is that correct?
Yes, ma'am, Your Honor.
All right, so first I need to ask you, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am, Your Honor.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am, Your Honor.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am, Your Honor.
And that you're waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am, Your Honor.
And that you're giving up and waiving the right to see, hear, and confront your accusers and all witnesses called to testify against you?
Yes, ma'am, Your Honor.
And that you're giving up and waiving the right to see and review evidence and present witnesses in your favor?
Yes, ma'am, Your Honor.
You're giving up and waiving the right to the assistance of an attorney?
Yes, ma'am, Your Honor.
And you're waiving the right to have the state to prove the charges against you beyond a reasonable doubt?
Yes, ma'am, Your Honor.
And you're prepared and agreed to waive these rights today?
Yes, ma'am, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am, Your Honor.
Has anyone promised you anything to plead guilty?
No, ma'am, Your Honor.
And do you understand that if you're currently on probation, your probation may be revoked because of this guilty plea today?
Yes, ma'am, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am, Your Honor.
So as to the charge of driving in a circular course or lane drag, how do you plead?
Guilty, Your Honor.
And as to the charge of possession of an open container of alcohol, how do you plead?
Guilty, Your Honor.
Okay, I will accept your negotiated plea as agreed today. And again, once you pay the fines of $700 plus court cost, then the third charge will be no prost, and then your case will be completed. All right. And
Yes, ma'am, Your Honor. Thank you.
that, oh, let me sign this. No cost. That. And then Ms. Franklin Redding is going to tell you where to go to pay the fines.
Yes, ma'am. Yes, ma'am.
Okay, thank you. And good luck to you. We appreciate your service. Or what you're getting ready to go do to serve. Have you been in before and you're going back, or no, this is the first time? Okay, all right, very good. Very good. Very good, and that is a good thing. Yes, yes, yes. You know, people go through periods of interesting judgment and situations, but the good thing is you're getting ready to go to another. I don't know, where are you going? I heard Deputy.
I was selected to be a pilot, so I'm going to officer training school. I'm going to be sworn in as a second lieutenant.
Oh, wow.
March 10th. I start on Tuesday, January 10th.
Oh, wow, great, wonderful. Gonna be up in the skies, okay.
I wish my wife was as forgiving as you. She still follows me to this day.
She'll get used to it with time, I know, right? Yeah.
I'm looking at the defendant's history, and I just want to verify something.
Yes.
Do not think, and this is not anything bad, Mr. Marlin.
Okay.
I'm looking at the history that you can
Right.
see if you have a current history.
Okay.
The one that we ran was in October of 2022, and it does not reflect October 6th, 2022. It does not reflect that the defendant has any other arrest. I would just ask the court to inquire of the defendant if that criminal history is accurate. And I'm asking that judge only because the state would not be opposed to the defendant entering a plea of no contest to the lane drags. The guilty to the open container, we would not be opposed to the court accepting a no contest plea to the lane drags if the defendant would like to enter a no low or no contest, no low or no low contender rate. What that would mean, Mr. Markham, is that you're not admitting guilt, you're not denying guilt, but you're entering a plea to no contest. You're not disputing the charges, but you would still be sentenced by the court as if you had pleaded guilty.
Yes, ma'am.
Okay, so you want to you want to change that plea on the lane drag to no contest plea?
Yes, Your Honor. I would like to change my plea to no local contest, please.
Okay, all right. Let's see, I'm gonna hand back, right, that one, so that, yeah, and then you can change the initial back to the no low.
Mark, I am going to circle where it says I hereby plead, I'm going to circle no low contendery, which also means no contest or no low, which means you're not disputing the charge, but you will be sentenced as if you pleaded guilty. I'm also going to circle that on the waiver of rights that you are pleading no low.
Yes, ma'am.
And again, but you will be sentenced, and this is no low as to the lane drags.
Right.
Yes, ma'am.
And I'm writing that on here, lane drags. And guilty as to the open container. And if you see what I've done, I'm going to initial what I've done.
Yes, ma'am.
Lane drags, no low. Open container, you're pleading guilty. And I'm initialing that I've done that. I've circled that you're pleading no low to lane drags. And on the very front cover, I'm also indicating that you are, besides everything else, that you are pleading no low to lane drags.
Yes, ma'am.
Okay, and guilty to open container.
Yes, ma'am.
Do you understand that?
Yes, ma'am, but may I please have just a little bit of clarity on how that affects my case? Because I know it's a positive. I just want.
Yes, it is. But with the NOLO, you can only plead NOLO every 5 years.
Yes, ma'am.
Use that once. And so, it goes on your record as a guilty, but it does not go against you. And I sometimes tell people for insurance or other reasons as a NOLO contender.
Perfect. Yes, ma'am. Thank you. I greatly appreciate you, ma'am.
Yes, and I, of course, I made Mr. Kirkland aware that I cannot advise him as a part of attorney for the state. However, it's the state's understanding that the Department of Driver Services views a no contest differently from a guilty as far as their assessment of points.
Correct, correct.
Thank you. Thank you so much.
Mhm. Okay. All right. I will close us out now that I've taken that plea, and everyone is dismissed. And I will see you all next time. All right. Have a good day, everyone.
And Ms. Redding, does he know where to go?
Yeah, I have to enter it.